North Buffalo house that sold at a foreclosure auction earlier this year is at the center of an ongoing legal dispute. When the property owner died, his son took over the mortgage payments to keep the house in the family.
But the family tells News 4 investigates the situation changed after the original lender merged with a different bank. Luke Moretti reports.
I feel really guilty that I failed my dad.
Mark Carey never expected things to turn out the way they did.
I lost at every turn and lost my dad's house.
Lost when it was sold at a foreclosure auction in January.
And that's a hard thing for me to swallow.
And just like that, the house in North Buffalo slipped away from Mark Carey and his family.
What happened to Mr. Carey should not have happened.
Long Island attorney Charles Walshine, who specializes in foreclosure law, is familiar with the Carey case.
If this was handled properly, the bank would have gotten paid every penny, and Mr. Carey would still have a house.
So, what went wrong? The house was owned by Mark Carey's father, Ronald Carey, who took out a mortgage in 2013 with First Niagara Bank. About a year later, Mark Carey started managing the mortgage payments and was added as an authorized individual.
It was a question of one phone call to First Niagara, and I was added to the account.
According to the Carey family, the process with First Niagara was seamless.
It was as smooth as silk. No problems there whatsoever. I had nothing but praise for them.
Linda Carey, Ronald Carey's sister, says when her brother died in 2015, the bank was notified, given the necessary paperwork, including the death certificate. As executrix of her brother's estate, she fully supported her nephew, Mark Carey, managing mortgage payments on the house.
And again, First Niagara was absolutely fantastic to work with. They said, no problem, Mark can continue to make the payments on the home and we'll keep going as is.
Mark, one of the heirs to his father's estate, says he decided to just make the mortgage payments rather than refinance. But he says the smooth, seamless process changed when First Niagara merged with and into KeyBank in October 2016.
And almost immediately from that point on, the issues began with they wouldn't discuss the mortgage account with me, they wouldn't take payments from me.
Linda Carey says just like she did with First Niagara, she sent the necessary authorization to KeyBank for Mark to manage the account.
And they would acknowledge receipt of the documents and receipt of the paperwork and receipt of my requests. And then it would just fall apart again and again.
Mark Carey says on occasion he would drive from his out-of-state residence to a KeyBank branch in Albany to make a payment in person. But even then, he says bank representatives would not discuss the account with him.
My issue was because they wouldn't discuss it with me, I would want to say, I shouldn't have to pay this late fee and these extra interest charges and fees that you're adding on here because I tried to pay on time and you wouldn't take the money. I'm sorry, Mr. Carey, we can't discuss this with you. And so I had no idea how much of my money was going to principal, interest. I never could dispute anything.
Charles Walshine, the foreclosure attorney, says there are privacy laws that banks need to follow.
And I'm sure the bank was, in that sense, correct. But he's got to show that he's the administrator of the estate. They have a reasonable duty to, to provide somebody at the bank who can help them navigate this problem. Because the truth is, what does the bank want? They want to get paid, and he wants to keep his house.
Linda Carey says there were conversations with KeyBank's lawyers, and that at one point it looked as though the problem was resolved. She says Mark was able to make a payment over the phone, but the next time the bank would not take the money. She even recalls KeyBank returning a check that her nephew mailed.
It was hell. It really was.
She says the situation took an emotional toll, especially when bank representatives would call asking to speak to her deceased brother about the mortgage.
And I'd have to tell them for the fourth time, the umpteenth time, Ron's gone. If I could speak to him again, I would love to, believe me. But he's not here, so neither of us can speak to him. And it just went on.
And so it was devastating for my aunt to get these repeated calls asking to talk to her dead brother.
The foreclosure matter ended up in state Supreme Court. A judge granted summary judgment in favor of KeyBank. The Carey estate then brought a motion to re-argue its opposition to the court's decision, but it was denied. In the decision and order, the judge states the foreclosure action is based on the failure of the defendants to make payments beginning in February 2019. The defendants have never made any arguments as to why they stopped paying the mortgage at that time.
They made a decision in 2022 to start the foreclosure process, alleging that I had failed to make the February 2019 payment, which is technically true, but what they don't say and what they never told the court was that they wouldn't let me make the February 2019 payment.
The real shame in this, it wasn't a lot of money. They could have easily made payments, and I don't think that KeyBank's internal I don't think the people who answer the phones, the customer service people, have any idea of what Mr. Carey's rights were or what the bank's obligations were.
Mark Carey, an attorney himself, filed a lawsuit in federal court in Ohio against KeyBank, claiming the bank refused to accept certain payments or discuss the loan with him.
I like to give people the benefit of the doubt, but I can't in this case. I just don't understand why it's gone on like this. What made it so difficult?
Mark Carey is also asking the court to transfer the civil case from Ohio to federal court in Western New York. KeyBank denies the allegations and filed a motion to dismiss Carey's complaint. In federal court papers, KeyBank argues that the claims are frivolous and without merit. And as far as transferring the case, KeyBank attorneys argue in court papers, plaintiff's motion to transfer is just another procedural maneuver designed to delay these proceedings and harass KeyBank and its counsel.
I'm not going to get my house back. I mean, it's been sold. But if something like this can happen to me, and I have at least the education and the resources to try to fight it and bring it to someone's attention, I know it's happening to other people.
KeyBank declined an on-camera interview, but released a statement to News 4 Investigates. Due to privacy regulations, KeyBank is not able to discuss matters involving clients and is not able to confirm whether a person or business is a client, adding, "We also cannot comment on matters involving litigation." Luke Moretti, News 4.